Hi, everyone. I'm excited to welcome you to our event today, which is a webinar on intellectual property from patents to trademarks and all in between. I'm excited to introduce our panelists. I'm Ashley Guernsey. I'm an innovation fellow at Center ICE, and I recently moved back to Alaska. I'm joined by Peter Webley, also from the Center ICE team, David Park, who is part of the intellectual property team and will be one of the speakers for today, and Charlie Brown, who's a partner at Ballard. This event is part of Startup Week, and Startup Week is a week-long event which coincides with Global Entrepreneurship Week. So this week we'll be here. We have a variety of events planned here at Center ICE in Fairbanks, but there are also events happening statewide around Alaska, and we're happy that you've joined us for this one. I'm going to open it back up to David Park to introduce Charlie and get the webinar going.
Thanks, Ashley. Just wanted to make a plug. I'm also a Patent and Trademark Resource Center representative for the USPTO here in Alaska. And as we'll be discussing intellectual property today, I wanted to mention this resource, which is available for all Alaskans, actually. Intellectual property in all its various forms, it's a really valuable part of research here at our university, but it can be a very valuable business asset, ranging from multinational corporations to the beginning stage startup. So I'm really happy to have Charlie here with us today to give this overview on this topic, just about what a patent, copyright, trademark, or trade secret might be, and what those differences could look like. Charlie is a partner at the law firm of Ballard Spahr, based out of Atlanta, Georgia, and he's a really longtime friend and outside counsel of the University of Alaska. He's a registered patent attorney with substantial experience in both patent prosecution and litigation, and he leads the electrical software and business methods team in the patent group at Ballard Spahr. Thank you so much for being here, Charlie.
Yeah, thank you for the intro. Let me get my slides going here. All right, hopefully everyone can see the slides. Great. So thanks again for the intro, Ashley and David. As I mentioned, my name is Charlie, and I'm going to talk to you today about intellectual property and the various types of IP and some differences in between all those. First up, we're going to talk about sort of like the role of intellectual property, and in particular in a university context. And so there are a myriad of reasons why a university might want to seek or otherwise protect its IP in the technology developed at universities. The obvious one for most intellectual property, right, is the barrier to entry, right? You want to be able to carve out your sector. You want to own the rights to keep other people from coming into your space, to give you some exclusivity in a market. It's also IP, like patents and copyrights, trademarks, also very valuable when negotiating, especially if you're negotiating for the sale of a company or a merger or a licensing deal. Having some registered intellectual property adds extra value into the negotiation process. Similarly, obvious follow-on to that is licensing revenue. A lot of universities make some money in the royalty space by licensing out its intellectual property, whether it be patents or even know-how is a form, but it's not really a protectable form. But patents, copyrights, trademarks can all be licensed out for royalties. Also, just like everything else in the world, it's all about how many patents might you be obtaining, or what kind of patents in what space, and there's a bit of a reputation boost that comes along with that. And then also for the professors and the researchers and grad students and undergrads, there's a bit of a validation, right? When you get a patent issued on your invention, it is the sort of the governmental seal of approval, right? That what you've come up with is new and is important and is a significant contribution in the field. And so, keeping in sort of line with university innovation, this is from a study from 2020. There hasn't been an update yet, but as you can see, patents issued each year to universities in the United States, and the faculty has increased about fourfold from 1980 up to about 2017. growing as a share of all U.S. patents issued to American inventors. And the number of spin-out companies that are been launched by university technology transfer offices, has increased from almost nothing, from almost zero startups back in the 70s to about 1,000 per year from the span of 2013 to 2017. And then sort of aggregate income that universities have made or have boosted from licensing out their IP has, and I think in the 90s it was around 200 million or so a year, to around 2015 it hit up to about $3 billion a year, which is a pretty significant increase year over year. And then when we look at, and so this is also pulled from, there's an organization called AUTUM, the Association of University Technology Managers, and they every year do a study of a survey of what universities are doing. And so some of the numbers, this is from the 2020 study, the 2021 still being assembled. Nonetheless, total research expenditures grew up to about 83 billion in 2019, which is it was like a 20% increase over a 5-year period. And as you can see here, there were over 27,000 invention disclosures in 2020, which was about a 7% increase, which is an invention disclosure is when a faculty member or student submits an idea to the University Technology Transfer Office for consideration for filing a patent application. And ultimately, patents issued over 8,700, which is about a 15% increase over the years. And really, I think this was a record year for startup formation. There were over 1,100 startups formed, and about 69% of those startups remained in the institution's home state, right? Which is an important fact, particularly especially for Alaska, right? We want to keep people there. So it's a lot of startups. Sometimes startups will form and then will relocate, maybe to California or North Carolina or some other area. But the university startups have a greater tendency to stay where they were formed. And as you can see here, here's just some values of reporting. Of licensing to startups, where you can see the number of licenses that are being offered up. Startups play a substantial role, but there's also smaller and larger companies that are at play, right? Because universities, at the end of the day, you can either do a startup and license the technology to the startup and see how it goes, or license the technology to a known entity that can take the technology and run with it. But you can see there's a mix with quite dominating the field is small company licenses, with large and startups being sort of second and third place. And then here's sort of the year over year numbers for startups formed and then startups that remained in the home state and then still operational at the end of the year. As you can see, the numbers just sort of keep getting better. But it will be very interesting to see when the survey is completed for 2021 to see. I think that's when we're going to get a much better impact of sort of pandemic related issues and see if the numbers, if the trend held or not. So when we think about sort of the role of the university and the role of a startup, it generally centers around economic development, right? University's role: teach, conduct research, serve the community, recruit, reward, retain faculty, create new technologies and expertise that's capable of being translated into a new industry. The startup's role is to provide the resources needed to commercialize the university technology and then create new jobs, particularly with focusing on employing graduates of the university, and then generate financial resources for the university and the state. And so together, the universities and startup have this symbiotic relationship that all just increases economic development opportunities within the state. Now, let's turn to IP, turn to intellectual property, and there's 4 different types that I'm going to talk about today. There's patents, trade secrets, copyrights, trademarks. Everyone's heard of all these, but sometimes the definitions of them get a little blended and a little bit mixed up in people's heads. So let's kick it off with patents, right? What is a patent? Well, and where do where's the power, the right of a patent come from? Well, it comes from the Constitution. In Article 1, Section 8, Clause 8, the Constitution grants the Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And so there's a constitutional mandate for the patent system. And what it boils down to is a patent is an exclusive right that allows you to exclude others from making, using, offering for sale, and selling that which you have invented. Now, it's important to note that I said exclusive right. It is not an affirmative right. And the difference there is an exclusive right is the right to exclude someone else from doing something, whereas an affirmative right would be a right to do something yourself. And that's the tricky part about a patent. A patent is not a right for you to do something yourself. It is a right for you to stop other people from doing what you've invented. Patents have a geographic sort of jurisdictional limitation. There is no worldwide patent, and each country of the world has its own patent system. Now, there are regional patent systems. Europe has a unified patent system, and in fact, they're getting ready to roll out sort of a new and improved European patent system, which is beyond the scope of today's discussion. But January of next year, they're going to roll out the unified patent system, which will allow you to get a truly, quote, European patent. As of now, if you get a European patent office may grant you a patent in Europe, but you have to then take that patent to each country in Europe and get a local patent of sorts. But the new and improved version is going to be a single patent for all countries that are members. Now, if you have a U.S. patent, then you can stop someone from making, using, or selling your invention in the United States, but you can't sue someone in another country for infringing your patent. Now, you can sue someone who's maybe making a product that infringes your patent and they're bringing it into the country. You can sue them for that. But if you want to assert your patent rights in a country, you're going to have a patent in that specific country, because no one patent covers the whole world. Now, when you talk about patents, you're going to hear things like provisional patent applications and non-provisional patent applications. And so what are they? So a provisional patent application is, I'm not going to belabor and sort of rattle these off to you, but a provisional patent application effectively serves as a placeholder. It is a filing at the patent office that draws a line in the sand and says, nothing after today can count against me for prior art purposes for the material that I've included in this filing. And so, when you file a provisional application, the patent office is never going to review it. They're never going to opine on whether or not it's that you have invented something. As a consequence, it can be in any kind of format. Now, mind you, you get out of it what you put into it, but there's no formal requirements of what has to be in the provisional patent application. And because it serves that purpose of sort of locking in a date, the tendency is for to focus more on as describing your invention as robustly as possible. Because what happens is 1 year from the date you file that provisional patent application, you must follow up with what's called your non-provisional patent application. And if you do that, if you follow up within 1 year of the provisional filing with your non-provisional filing, then the non-provisional patent application will be treated as if it was filed on the same day as the provisional patent application, but only for the material that's in common between the two, which is why you want to have a very robust provisional filing. So that way you have as much of a one-to-one parity between the provisional and the non-provisional patent application as you can. Now, the non-provisional application is the real application that the patent office is going to read and render an opinion on. And as a consequence, there are very specific requirements that have to be met for it to qualify as a non-provisional patent application. And it is the application that will be assigned to a patent examiner who will review your patent application and then issue usually a rejection, because the patent office's job is effectively to reject patents, and that begins the back and forth process of negotiating with the patent office what is truly inventive. And then if a patent is going to be granted, it's going to last for 20 years, and it's going to start from the date you filed the non-provisional, not the date you filed on the provisional. And so, it's 20 years from the date of the non-provisional filing. However, for prior art purposes, and remember, prior art are any documents or any products that were in existence or publicly available prior to your filing date. And those documents are the documents the patent office will use to assess whether or not your invention meets the criteria for patenting. And I'll go into those criteria in a few minutes. So you wind up being able to, if you use that 1 year, you can use that 1 year to your advantage. So if you file the provisional and then you wait the year for the non-provisional, it allows you to sort of keep that early date, and that 1 year is used to do things like test your invention, further develop it, identify additional aspects that you might want to include in the non-provisional, with the caveat being, remember, if you come up with something new 6 months after the provisional is filed, and then you file it, you include that material in the non-provisional, that new stuff may not get the benefit of that earlier date, but it allows you to do that. Because once you file the non-provisional patent application, it is effectively in stone. You can't really modify what's in there or what's described as the invention. And also, when you file the provisional application, you can immediately list patent pending. And of course, when you file the non-provisional, you can continue to list patent pending. And one thing to think about is the United States shifted over a decade ago to sort of a system of first inventor to file, which is, think of it as a little bit of a race to the patent office. We used to be the first to invent country, one of the few in the world, which meant that if you filed a patent application for an invention and someone else filed a patent application for the same invention, the patent office would investigate and try to figure out who actually invented it first, without regard to when you filed your patent application. Now we're sort of more in line with the rest of the world on whoever kind of gets to the patent office first as an inventor will be the winner of sorts. So let's look at a timeline that you might encounter for filing a provisional application and your non-provisional application. So you have, at month 0, right, you file your provisional application, then 12 months later is when you file your non-provisional patent application, which will then publish 18 months later. There's another application. Now, remember how I mentioned that there's no worldwide patent. There isn't, but there is an application that's referred to as a PCT, which stands for Patent Cooperation Treaty. And most countries of the world are members of the PCT. And the PCT is a mechanism by which you can enter into all those various local jurisdictions of all those other countries and get patents there. So you could file a provisional application, and then 12 months later, you could file a PCT application. And then 30 months from the provisional date, or 31 months, depending on the country, you would enter what's called the national phase, which is basically filing a local patent application in a specific country. And so the PCT application, very much like a provisional, doesn't really get examined thoroughly. It cannot become a patent. Now, the PCT search authority will issue a non-binding opinion on the patentability of the invention, but the PCT application cannot become a patent itself. It is more of sort of like a lily pad of sorts as a way for you to get your patent application into the local patent systems of all the various member countries of the PCT. And this is just an example filing timeline. There are a lot of different ways to do this. You could, for example, not file a provisional application at all. You could just go straight to a non-provisional. You could file a provisional and just a PCT, and then you could enter the United States through the national phase process. There's a lot of different ways you can think about strategically how to file your patent application, and there are various sort of cost and timing concerns that can come into play to inform which route you take. So let's say you filed your patent application, right? What happens next? Well, this is an example sort of patent process that starts all the way from, researcher, coming up with an idea, coming up with an invention, and filling out the form and submitting the invention disclosure form to the tech transfer office. Tech Transfer Office may engage in a patentability search to sort of see what's already out there, kind of gauge the odds of obtaining a patent or not, or obtaining meaningful protection. At which point, if that's a go, then we'll prepare an application, file it. You will wait anywhere from 2 to 4 years, although the PTO is getting better. It's closer to 2 years for most applications. After that, wait, and a patent examiner that is sort of skilled in the area of the invention will pick up the patent application, will read it and read what you claim as your invention, and will conduct their own patentability search to look for prior art. And then that examiner will issue an office action, which 9 times out of 10, 9.5 times out of 10 will be a rejection. It will say, you cannot have a patent because I found this document or this combination of documents that I believe teaches your invention. And that's sort of the start of the back and forth process with the patent office, where we will prepare and file the response to that office action, where we maybe make an argument that the prior art is being interpreted incorrectly, or we might be able to tweak our claims a little bit. You can modify the claims. You cannot modify the description of the invention, but you can modify the claims to try to avoid the prior art. And there'll be several rounds of that. I'd say here 1 to 4 times. That's sort of on average. And after you go through several rounds of that, and if it looks good, the examiner will issue what's called a notice of allowance, which is sort of saying the examiner says, yes, you can have a patent. A few months later, after you pay the patent office the issue fee, the patent will issue, and you'll have a patent that is good for 20 years from the date you filed the non-provisional patent application. Now, let's talk about what the examiner is going to do. And when we think about that, we got to think about what is patentable. And the statute that defines what is patentable is under 35 USC 101. And it states it pretty plainly. It's whoever invents any new useful process, machine, etc., may obtain a patent, therefore subject to the conditions of this title. Now, what does that mean? Well, it means it's a pretty broad statement. And there's a Supreme Court decision from 1980 that went so far as to say a patent may be granted for, quote, anything under the sun that is made by the hand of man. And so it feels like a pretty expansive definition, but there are some limits to it. Generally, what's considered to be patentable subject matter are things that fall under what's called the sort of the 4 statutory categories: machines, compositions, articles of manufacture, methods, or processes. And what falls under these categories? Machines, things that have parts that move or interact with each other. Compositions or drugs or pharmaceuticals. Articles of manufacture will be maybe like a tool, like a screwdriver or something that's more of something that doesn't have any dynamic or moving parts. And then methods might be, diagnostic methods, methods for making a drug or software would fall under the method category. What is not patentable subject matter? Well, courts have interpreted that statute, 35 USC 101, and come out and said, well, you can't get a patent on laws of nature, natural phenomena, or abstract ideas. And there's a whole other sort of lecture series I can go into this concept about what does it mean to be an abstract idea, or what does it mean to be claiming a law of nature? Because, pre-2014, we had a pretty solid understanding of what it meant. And then in 2014, the Supreme Court came down with a decision we refer to as the Alice decision, which stated that you can't get a patent on an abstract concept. For example, a fundamental economic principle you cannot get a patent on. But then the court really didn't give us much more guidance than that. Now, since that time, we've gotten a lot of guidance from the Patent Office itself and various other courts in the United States about what is and is not in sort of the bounds of abstract concepts. And we're in a better position today than we were in 2014, but we're still nowhere near where we were in 2013 with regards to reliably being able to assess whether or not something is or is not an abstract idea. And there's a little bit of variability at the Patent Office that comes into play that makes that a little bit more difficult. But nonetheless, you cannot patent something that is just merely an abstract idea. Think of a mental process or something that can be completely done in the human mind, or think about trying to just patent what is effectively just a mathematical operation. Those are examples of things that are abstract ideas that you're not allowed to get a patent on. Where it gets tricky, though, is what happens if you have an invention that is based on or is otherwise relies on some sort of mathematical operations, but you're not technically trying to, quote, patent math per se. It can get kind of tricky and kind of dicey. And there's a lot of arguments that go back and forth with the patent office on what is and is not abstract. Now, your patent application will also be examined under two other statutes, 35 U.S.C. 102 and 103. 102 relates to the novelty requirement. It seems kind of self-explanatory that if you're getting a patent on something, it has to be new. It has to be the first time anyone has ever proposed this idea that you have. And the patent office will try to find a prior art document, maybe an earlier patent application or earlier patent, or maybe like in a manuscript or an IEEE article, for example. They'll try to find one source, and if they can find one document that teaches everything that you're claiming is your invention, the patent office will say that your invention is not new, it's not novel, therefore it fails under the 102 test. The other test is the obviousness test, and what you want your invention to be not obvious. And the patent office, if they cannot show that your invention is not novel, they will look to find, is there maybe a combination of prior art documents that they could put together that when you look at all of them together would teach all the limitations that you're claiming is your invention, and that somebody would have been motivated to combine those references together in a predictable format with a reasonable expectation that that combination would be successful. And if the patent office can do that, then they will try to say your patent application, your invention is obvious. And so the way we treat these rejections are, we can maybe either amend the claims, but we always usually also put in arguments if we feel the patent office is maybe interpreting our invention a little incorrectly, or if we feel that the patent office might be interpreting prior art documents a little incorrectly. And so you can try to argue and amend the sort of statement of invention to try to address these novelty and obviousness rejections. Another issue we face with patent applications are you have specific disclosure requirements. The quid pro quo that you enter into with the government is in exchange for 20 years worth of monopoly, you agree to teach how to make and use your invention. And so you must describe your invention in your patent application in such a way that someone of skill in the art could pick up your patent application, read it, and then understand how to make and use the invention without undue experimentation. And that's oftentimes referred to as the enablement standard. You also have to convince the patent office that you were in possession of the invention at the time you wrote it, which gets into an issue of reduction to practice, right? Because once upon a time, you had to actually maybe make the thing that you invented, and the patent office could make you bring it in, right? Most often used for perpetual motion type inventions, where if you've invented a machine that has sort of infinite energy producing capability with 100% efficiency, patent office might ask you to just bring it on down and show it to them, as a way of sort of defeating that patent application. That doesn't really happen now. And what happens is, if you're capable of writing your patent application, putting it together in such a fashion that someone could reasonably create your invention based off of the document, then you will have constructively reduced your patent application when you've put it together like that and filed it. So patent applications they discuss and describe inventions, but inventions come from inventors. And so who is an inventor? Well, courts have defined this for us and have laid out that in making an invention has 3 steps: conception, activities leading toward that reduction of practice, and then reduction of practice. And one of these is the controlling feature for inventorship. And spoiler alert, it's conception. And these are some catchy phrases that the courts have used to describe how important conception is to invention, so much so that they've characterized conception as the touchstone of inventorship. It's the formation in the mind of the inventor of a definite and permanent idea of complete and operative invention, as it is thereafter be applied in practice. And so Inventorship now, we measure that against what's called the patent claims. Patent claims are a very concise definition of what you consider to be the invention. The patent claims are statements that the patent office will review and try to find in the prior art. And so if someone contributes to the conception of at least one of those limitations in that patent claim, then that person is an inventor. So what that creates is an issue of you can't really determine who's an inventor until you have those patent claims. And so if you have a patent claim, you can interview everyone who may or may not be an inventor and try to assess who truly conceived of one of those limitations. That's to be contrasted with someone who may be executed on someone else's vision. Happens a lot of times in software patent applications where maybe you have a new idea for way some software related invention might work, but maybe you're not a very good programmer or don't know how to program, and you can hire a programmer to sort of create the actual tangible embodiment of what you've invented. If that's all the programmer does, then that programmer is most likely not an inventor, because that inventor, that programmer would not have contributed to the conception of any limitation of a claim. In the university context, we often bump into inventorship issues when we're basing a patent application off of a manuscript or journal article. And what happens is there is not a one-to-one relationship between authorship on a journal paper or manuscript and inventorship on a patent application. Because oftentimes authors on a paper might include sort of everyone that would potentially was involved and contributed to what's in the paper, which would include folks like the programmer or maybe somebody who just provided some data that assisted in the project. And I give this as an example. This reference to this citation is to the article that describes the discovery of the Higgs boson. And the joke here is that et al. is over 5,000 other authors that were all listed as contributing authors to that paper. I cannot imagine filing a patent application and sort of straight face saying that there are 5,000 inventors on a patent application. It would almost be sort of dead on arrival. I don't know that anybody would believe that. So that's one thing you have to keep in mind in the university context is putting someone on a paper doesn't necessarily mean that they're an inventor on a patent, on an invention that would be described in a patent application based on what's in that paper. Things you need to be careful of. Public disclosures. So in the United States, we have a 1-year grace period from the first time that you publicly disclose your invention. Now, what is a public disclosure? Well, not everything is a public disclosure. There are certain exceptions. For the most part, your public disclosure needs to be enabling. Remember how we described earlier about the enablement standard that someone has to be able to practice or be able to make the invention. There has to be sufficient detail in your disclosure that teaches that someone will be able to take your suggestion or your disclosure and go practice the invention. If it's not enabling, then that weighs against it being found to be a public disclosure. In the university context, we're often asked about grant applications or grant proposals. Those are generally held in confidence. However, if they get funded, then those are prior art or public disclosures technically as of the date they get funded, because someone could technically, as of that date, file a FOIA request to get a copy of the grant. Nothing to keep an eye on are manuscript, journal articles. When they get submitted, they're oftentimes sort of advanced publication on the web or sometimes mailed out. And so you got to be mindful of those dates that, just because you've submitted it and maybe the journal told you it'll be another month, it might be a month till it's in hard copy, but it might be in soft copy of publicly available before that. So that's something to keep in mind. And there's this classic case that if there's a thesis and it's in a public library and it's indexed, then it's prior art as of the date it was indexed. And this is true even if it is a thesis in the most sort of remote library that you can think of, so long as that library is available to the public. At conferences, posters and abstracts can be public disclosures. Again, question is how enabling is it? And then any any contact or communications with any personnel outside of your organization, whether it's a university or if you're in a startup, any communication with anyone outside of the organization would count as a potential public disclosure. And then similarly, if there's department meetings or thesis defense sessions that allows people from the outside in, those could count as public disclosures. So what can you say, or what should you say? Well, the first question is, as I say here, is consider the audience. What do you need to say anything at all? However, if you do, then the best recommendation, the best practice is to get your provisional, at least, patent application on file. And then you can say whatever you want, so long as what you're saying is described in that patent application. At that point, it doesn't really matter if it's a public disclosure, because you've already filed your patent application and your 1-year timer doesn't start from the public disclosure date. Now, if you filed a provisional, you still have the 1-year timer for filing your non-provisional, but the public disclosure that you make after filing your patent application doesn't count against you. And so far, what we've been talking about have been we would call it like utility patents, non-provisional patent applications, which really go to the how something might work, the function of something. But there is another kind of patent. It's called a design patent. And a design patent is a protection that is afforded to the sort of an ornamental feature or ornamental design of an article of manufacture. Now, it's for a shorter term than a normal utility patent. It's only 14 years. And it protects again for the ornamental features. It does not protect sort of the functional features of anything. And design patents are very interesting because they're very drawing focused. And so, as you can see here with this dog sled, the way that you can read a design patent is you look for the dashed lines and the solid lines. And anything that's a solid line, this person is claiming as their unique design. Anything that's the dashed line is not part of the unique design. So in this instance, the person and the dogs are not part of the design, and perhaps maybe that front leg of the sled is not part of the design. But this person's claiming this sort of tubular looking design for this sled, this dog sled. This is where copyright does sort of blend a little bit with design patents, because they're sort of both protecting to some extent an expression of something, the way something looks, again, as opposed to the way something functions. Now, design patents can be incredibly valuable. Maybe 10-ish years ago or so now, there were sort of like the big Apple-Samsung wars, where Apple and Samsung were kind of duking it out in the sort of patent litigation battlefield. And Apple looks at this design and can immediately recognize this is sort of like that. It's like the first Apple phone, I think, the first iPhone here. This is a design patent, right? And so, the design patents that were at issue when Apple won this case ultimately were part of over sort of $500 million in damages. And so, design patents can play a pretty critical role in defending your intellectual property. The next form of IP we'll talk about are trade secrets.
Charlie, if I
Yes.
could interrupt you just very
Sure.
quickly. Jonathan had a question about provisionals.
Sure thing.
He asked, can you explain how quote unquote rolling provisionals work, where you modify or update your provisional with new information?
Sure. If you, what you can do, there's no requirement that you have one provisional going to one non-provisional. So a common strategy, if you're going to further develop your technology, is you can file a provisional application on what you have now. And then maybe in a few months, if you've developed some additional aspects to the invention, you can file another provisional. And you can do that. You can file as many provisionals as you want. And then what people will do then is 1 year from the earliest provisional, they will file the non-provisional and claim priority back to every single one of those earlier filed provisional applications. So I think the most I've ever had is like maybe 4 or 5, where there were a lot of rolling provisionals. Now, the other thing you can do, excuse me, is if you've sort of maintained the secrecy of your invention and you file a provisional application, and then you make further developments, 6 months later, you file another provisional application, and now you're 1 year from that first provisional, and you want to file your non-provisional. If you're still not quite ready for the non-provisional, you can technically expressly abandon that very first provisional application, including abandoning the right to claim priority to it. And so long as you still maintain the secrecy of your invention and have not publicly offered it for sale or publicly disclosed it, then you can treat that second provisional as if it was your first one, and you can continue to do that. Now that gets tricky, right? Because it keeps harder and harder to keep the sort of the genie in the bottle, but that's another way to do it. So you can either keep filing provisionals, and when you're at the 1 year from the first one, you can claim priority to all of them, or there is a strategy by which you can sort of give up the first one or even the second one. But a lot of other things have to be just right for that to be a realistic strategy.
Thanks, Charlie.
Sure. So the next type of IP we'll talk about are trade secrets, which are generally thought of as formulas, patterns, basically anything that's not generally known to anyone, like the people don't know how to do it, and that it's protectable as long as it remains a secret. Which, think about that. What that means is it's something that, and I'll get to this in a minute, can't be reverse engineered. It's not something that's just sort of out there that someone could figure out easily, right? So long as it remains a secret, that you can protect it. And then you take, quote, reasonable efforts to maintain secrecy. And now, what does that mean, right? Because oftentimes we'll have conversations with folks who'll say, well, I don't want to patent that, I'll just keep it a trade secret. And then they don't really do anything. And you have to exert certain efforts to keep it a secret. And I'll get to that more in a minute. Now, a few things about trade secrets, though. They're unlike a patent, which has, government filing fees, and you wind up racking up attorney bills, right, helping you prepare the patent application and shepherd it through the process. Trade secrets, there's no cost, right? There's no trade secret office, right? So there's no registration fees. And a trade secret, unlike a patent, we know, which lasts 20 years from the non-provisional filing, or 14 for the signed patent. Trade secrets are forever, so as long as you can keep it a secret anyways. And they're effective right away, right? You don't have to wait and establish that something's a trade secret. And so coming back around to it being as long as you can keep it a secret, well, you have to do things like make internal policies. You have to have people typically sign agreements that they recognize the significance of the trade secret and the damage that could be wrought if it escaped. And you have to you can't have a sticky note with the password to the server sitting on top of the screen, things like that. You actually have to treat it like it is a true trade secret, that it would be the end of the world if it got out. Now, the risks you take, right? If someone's able to reverse engineer your trade secret, you have no cause of action. And also, if someone separately just sort of comes up with the same same technology or same developments without looking, without taking it from you, without stealing it from you, then you can't do anything about that. And so, if someone acquires a trade secret through these legal means, you have no remedy. Now, if somebody, oftentimes trade secrets come into play if an employee leaves, and then a week later they have a fully operational company doing the same thing they were doing at the former company. That's usually evidence that they took something, and so that's where trade secrets can come into play, is typically to look at employee theft. I'm going to be sensitive to time. I want to sort of move through these kind of quickly. So copyright, right? So copyright, protects, quote, works of authorship that are fixed in a tangible medium of expression. Examples that you normally think of when it comes to copyright are books, pictures, paintings, sculptures, things of that nature. And copyright is oftentimes thought of a sort of a bundle of rights, or like the bundle of stick approach, where you can license out individual pieces of your copyrights. You could, for example, license someone the right to perform the work publicly, but they're not allowed to distribute copies of it or to make derivative works or things of that nature. Or you could license out the whole kit and caboodle, but you're able to license out selectively certain parts of your copyright. How do you get a copyright? Well, you have a common law copyright as soon as you have sort of affixed the work in a tangible medium. What does that mean in normal language? As soon as you've sort of written the poem or painted the painting or taken the picture, as soon as that happens, you have a common law copyright. However, you still should register it if you want to ever sue anyone for copyright infringement. Now, because if someone copies your materials, then if you want to sue them, you have to go to federal court, which requires the registration with the Library of Congress. And there's a nominal fee for that process. Copyrights last quite a long time. Presently, it's life of the author plus 70 years. If you made it yourself, or if you paid someone to make it, you get 95 years from the first publication or 120 years from creation, whichever shorter. And typically it's whenever Mickey Mouse is getting ready to come off copyright that these laws get amended. And the key takeaway about copyright is it's the expression, it's not the idea, right? So it's the drawing of the thing, it's not the thing itself. An example I give for the sort of the software nerds out here is, what's the idea versus the expression of the idea, right? This is, normally I try to see who knows what this is, but I'll just tell you, it's a bubble sort, right? This is code to do a bubble sort. And what you might potentially have is a copyright in the code, so that nobody could, if someone copied this code and used it, then they would theoretically have infringed your copyright. But if someone else wrote different code without knowing about your code or seeing your code, someone wrote different code to do a bubble sort, then you would have no cause of action, because remember, your copyright's in your particular expression, not in the concept of the bubble sort. Now, there's another issue that we refer to as sort of the merger doctrine, which, prevents you to use copyright as, a way to protect an idea, which would be thought of sometimes as a patent by proxy, where if there's only a limited number of ways to express something like the bubble sort, then there may be no copyright protection afforded, because the idea has effectively merged with the expression of the idea, such that it would not be sort of a good public policy to allow someone to have a copyright in that material. And so, as I mentioned before, it doesn't protect against what we call independent creation, right? So if you wrote a poem and someone in Florida writes the same poem but never had access or copied your poem, then they were an independent creator of the same thing. And they could have a copyright in theirs and you could have a copyright in theirs, but you couldn't sue each other for infringement because neither one of you actually copied the other. And here's a short summary slide where and I'll provide these slides for distribution, short summary slide that lays out some pros and cons differences between patents and copyrights. Finally, I want to get to trademarks, right? What is a trademark? Trademark is anything that identifies the source, like where does the thing come from? Who made this thing? And it has to be used in commerce, which is in contrast to copyrights or patents or trade secrets even. You have a patent no matter if you're selling a product that is embodied that embodies your invention or not. That patent is good as long as you pay the fees of the government. A trademark, though, is only good so long as you're using it. And so if you're using it and it's distinctive enough and you can get a registered trademark on it, you can sue someone for labeling their products with the same or a mark that's similar to yours, such that it would cause a likelihood of confusion in the consumer as to who is the source of these goods. And they last forever. All you do is keep paying your fees so long as you continue to use them in commerce. Thing about trademarks is you can lose them if you do not police your trademarks, right? If you know someone is sort of knocking off your trademark, selling something under your mark, and you just let it happen, then that inaction can result in you sort of forfeiting rights in your trademark. If you don't use your trademark, you can lose it. If you use your trademark improperly, like as a noun, for example, you can lose your trademark. And then, of course, these are always fun, what we call genericide, right? When your mark becomes generic, when your trademark has become the name for the thing, right? Like Kleenex or thermos or aspirin. These used to be trademarks. And that's why you see Kleenex will offer advertising, Kleenex brand tissues, right? As opposed to using Kleenex as a noun. If your market obtains sort of a generic status, you can lose rights in that trademark. And then of course, failure to police is the issue where if you fail to sue someone. Now, I don't have time to get to this IP case study. I want to be sensitive to questions at the end. If there are any more, if there's no questions, I'll try to go through this quickly.
Actually, Charlie, there doesn't seem to be an open question right now, so
I'll get moving. Let's do this. Sure. This is fun. So Candy Crush, right? We all know the game. And so what we'll talk about is sort of the Candy Crush intellectual property saga rather than just Candy Crush saga. So there was a game called Candy Swipe on the left, which was released 2 years before Candy Crush. As you can see, they're very similar. It's the same concept, a match-3 game. The 3 things that you matched, or the more than 3 things that you matched, will disappear. More game pieces fall from the ceiling, and you continue to do that. And Candy Swipe was a game written by sort of a garage inventor sort of guy. I think the story is he wrote the program for his mom to have a game to play on her phone. Now, you've probably never heard of Candy Swipe, and you can't go really download Candy Swipe and play it because Candy Crush dominates the market. Now, you got to ask, what could Candy Swipe have done to have been the dominant player? Well, Candy Swipe could have tried to get a patent, right? They could have tried to patent the inventive thing, concept of this match 3 elements on a screen and have them disappear. I think he would have had a hard time just because there were some games that predate this, and this isn't a new game, really a new game concept. There was a DOS game, if anybody knows what DOS is anymore, called Shariki. That's on the left, the same concept. And then a lot of people are still familiar with a game called Bejeweled, similar concept in 2001, which predated the Candy Swipe game. And so, these are examples of prior art that would have been used to try to defeat any attempt to get a patent on the Candy Swipe game. And so Candy Swipe guy didn't have a patent. And Candy Swipe guy didn't really pursue any kind of copyright lawsuit, right? You can look, there's a comparison of the game pieces and the use of the word sweet when you get a really good match. There are some similarities here, potentially coincidental, potentially not. However, despite these similarities in graphics, there was no alleged copyright infringement, and there was no allegations of any source code copying, right? Because remember, to sue someone for copyright infringement, you have to prove that they had access to your copyrighted materials and then they in fact copied it. So there was no evidence of that. And then I always talk about trademarks, right? Well, Candy Swipe guy had a trademark. And so that's sort of where a lot of this sort of saga centered around was the concept of trademarks. He had a trademark in Candy Swipe. And the problem is King, the company behind Candy Crush, had marks that were after and sort of less superior in a way to the Candy Swipe mark. However, King found another company that had a game called Candy Crusher, and the Candy Crusher guy had a trademark on Candy Crusher that he trademarked in 2004, which was 6 years prior to the Candy Swipe guy's trademark. And so they were able to use the Candy Crusher mark to really cancel, in effect, the Candy Swipe guy's trademark, and King was able to establish superior rights in the trademark. And King has been a sort of a prolific enforcer of their trademarks. I told you how you can lose your trademark if you fail to police. If any game pops up on any app store that has anything to do with candy, then King will approach them. There was an example of a game called All Candy Casino Slots, and King approached them and got them to rename their game to All Sugar Casino Slots rather than have candy in the name. And why does it matter? It's just a silly iPhone game. Yeah, well, here's from I think this is June of 22. Candy Crush was still pulling in, just north of $25 million. And I believe this is a month. So if Candy Swipe Guy had managed to get a patent, imagine where he would be now, or if he had managed to really establish any kind of copyright claim, where would he be now? But King was able to sort of outfox him and get that earlier Candy Crusher trademark, which was sort of which defeated his sort of best angle at getting one over on the big guy. So this is a Goliath winning over David's story. So it's not very inspirational, but it is a sort of a lessons to be learned here in things you could do to protect yourself so that you don't get candy crushed is one way to think about it. So I don't know if there's any other questions or not now, but I want to make sure I leave time for Ashley to wrap up.
Before Ashley wraps up, thanks, Charlie. That's a really interesting IP study. I think it really goes to show how many of those 4 different IP aspects could be involved in one service or product or system. So it's very, very interesting, and it could have a big effect on a business. But,
Yeah, absolutely.
Thank you so much for that whirlwind overview of intellectual property.
Happy to do so.
Yes, thank you so much, David and Charlie, for sharing about the intellectual property side. I'm going to go back to sharing the screen and talk a little bit more about what events are upcoming for Startup Week. Thank you both for being here and being a part of Startup Week. We have a lot of other events that are still upcoming, despite there only being a few days left this week. One of the ones that I want to highlight is a social event, which is happening here in Fairbanks, and with a code that we'll share discreetly in the chat, you can actually come and get a free beverage at the venue as part of the social event. So make sure to go to the schedule and check that out if you're located in Fairbanks and interested in joining us and some other innovators. We'd also like to thank the sponsors of Alaska Startup Week, including the organization that I'm a part of, Center ICE, for kind of running a lot of these events. And then the sponsors throughout Alaska, which are here on the screen, as well as Techstars, which is kind of the overarching organization that's putting this event together in Alaska, and those volunteers. And then this is Alaska Startup Week. Thank you also very much for joining us, and have a great rest of your afternoon.